Good morning. We are now in for the second session, which pertains to duties of police under the new scheme. And for this particular session, we have with us Mr. Vikas Pahwa, the senior advocate. You know, to have a senior advocate, and that too of the stature of Mr. Vikas Pahwa, for a program of this kind is something, a kind of an achievement itself. A third generation criminal law lawyer started his career in the year 1993. And at the age of 42, he was designated as senior advocate. And in the field of criminal law, you name a particular case as such where he has not been engaged or has not contributed meaningfully, successfully as such. He is so much in demand in this particular field. The criminal jurisprudence, he has been a part of it, developing it in such a manner. And particularly this, his focus into that, his competent persons who will richly contribute. Yes. And request
Good morning. Am I audible? I'm sorry. I think there is a problem in the audio, so therefore I missed what Dr. Balram Gupta said in the end. Have I been told to start my talk today, or I just missed the last few minutes?
and sharing with everyone
Yes, sir.
how difficult it is for a senior advocate to spend time
Sir.
for a workshop of this kind.
Yeah.
And therefore, I'm doubly grateful to you that you spared the time and you're contributing effectively into this particular. May I request you to kindly.
Thank you. Thank you, Dr. Balram Gupta, Director of Chandigarh Judicial Academy, for inviting me today to speak on something which is so unique. It is my proud privilege and honor to speak about the motor accident claim under Central Motor Vehicle Amendment Rules 2022, which have been framed by the government recently. And why I immediately agreed to speak on this is because of my long association with this case. And so, if I may be permitted to say that these rules today are possible only because of single person's effort and the way Justice Midha cultivated this case since 2008, 2009. And if we see the judgment of Rajesh Tyagi, the matter belongs to the year 2003, but it actually picked up the speed in 2008, 2009. The date of his elevation, he was elevated on 11th of April 2008. And if we see the judgments and the orders which have been passed and how Rajesh Tyagi 1, Rajesh Tyagi 2 and Rajesh Tyagi 3 came. Sir, am I audible? Is everybody can hear me?
Yes, sir.
Sir.
Right. So I was just narrating, the history to these rules. Normally, when the rules are framed, a statute is, introduced by the parliament, then there is a legislative history, which is important to, analyze. Now, in these rules which have been notified, there's hardly any legislative history, but there is a long judicial history. So therefore, since 2008, 2009, Justice Midha, when took over this appeal of Rajesh Tyagi, we saw that series of orders were passed and how those series of orders have resulted into various rules and various agreed procedures. It started in 2009 on 16 December 2009 when this claim tribunal agreed procedure was envisaged by the court, and then how they were implemented by the Delhi police. It has a 4-5 minutes on it just to apprise everyone how this all started. And then, of course, I will discuss how the investigating agency was introduced in this entire procedure. So, conventionally, if we see, the motor accident claim tribunals used to work on their own. I'm talking about prior to 2008, 2009. The procedure which was followed was procedure under the Act. The tribunal used to try the cases and it used to take about 10 years for a case to be decided, and then the compensation or claims are decided, given to the victims. But now you will see how the procedure has been changed and how the element of investigation is also imbibed into this entire procedure. How the investigating agency is also brought, because there is certain evidence which is not in possession of the victims and the tribunal. So how, in a very, very intelligent manner, how an agency is being used to make sure that the claims are decided at the earliest and the victims paid, normally in a short period of time are paid and they are compensated for their losses. So I must share that in 2009, when this entire process started, I was the additional standing counsel of Delhi Police, and my Lord Justice Midha was handling this matter, and I was given the brief to appear before his court and to represent Delhi Police. There, this entire effort started, and Justice Midha envisaged this process and involved the Delhi police, and also openly said that we can't achieve this unless and until the investigating agency is brought into this entire process of inquiry. was formulated, where the whole objective was that the victim should get the compensation within 90 to 120 days. And then the Delhi police took up, this process and agreed that they will work on it pursuant to various orders which were passed by the court. And then they prepared a manual among the various officials as well as the legal department, and it was also put before the court. When it was put before the court also had a look at it, and Justice Midha affirmed it and said that, well, it is very nicely prepared and let us see how this pilot project can work. And it is only pursuant to the direction passed by Justice Midha that this process started, and it went on for many years. In 2010, 2011, 12, 13, many orders have been passed. And then subsequently, when it was noticed that there are certain lacunas in the scheme, then this Rajesh Tyagi 2 was introduced and certain modifications were made. And ultimately in 2018, Rajesh Tyagi 3 came, and then some more modifications were made. So this process, which started in 2008, actually got concluded in 2021. So I must say that during this entire tenure of Justice Midha, right from 2008 to 2021, one of the major energy which was focused was in this process, which ultimately was noticed by the Honorable Supreme Court. The Honorable Supreme Court also passed various directions where the Honorable Supreme Court said this is one of the best procedures they have ever seen, and then it should be formulated and it should be accepted by other states. So directions were passed, the committees were constituted. A lot of hard work has gone into all this. So in 2020, when the Delhi High Court Justice Midha saw that, yes, although the ball has been set rolling, but there are certain requirements, there are certain legislative requirements, because it has to be legislated, the rules have to be framed. Then I think last couple of years of his life as a judicial officer, as a judge of the Honorable High Court, he focused so much of energy into this and, introduced, called a lot of amicus curiae. I was part of it, and various other, very senior renowned lawyers were also part of it. And then this agreed procedure was formulated, and ultimately it was given a shape and a judgment has been passed. And that judgment was passed on 8th of January 2022. So a lot of hard work, a lot of comprehensive study which has been made by various quarters, the Transport Department, the Honorable Judge, and the stakeholders. Everybody is heard. The insurance companies were also heard. And ultimately this judgment has come, which is one of the most remarkable judgments I've ever seen in my life. And that is why I said in the beginning that this is one set of rules, which doesn't have a very comprehensive legislative history. It has a judicial history. So it's a great reading. I must request everyone to read it very, very carefully, the judgment, how it all started, and how these forms were prepared. And the forms, again, each and every form, there are about, I think, 15, 16 forms. Each of these forms have been discussed threadbare. Each and every form was discussed and said that whether there's any violation of any constitutional right or not. So total are 19. There are 19 forms in this entire scheme. So when the forms were discussed in the court, were looked into, the procedural rights were looked into, Motor Vehicle Act was looked into, CRPC was looked into, Evidence Acts was looked into, and IPC was also looked into. Each and every law, which is probably done in the parliament, is done in the court in this case. And then each and every the requirement of the form was discussed and we all made sure that the forms should not violate any constitutional provision or any law. It should not be ultra vires, to any statute. And we are so happy to see that with this, commendable effort of Justice Midha, we have come up with a document which does not violate any law at all. So a great study has been done. And now, since my duty today is to primarily talk about the intervention of the police authorities, the investigating agencies, and what all they need to do. So it's very important that we understand what their duties are. the investigating agency should understand, the judicial officers should understand, the insurance company also should understand, and of course the victim and the accused person. So what has been done, what is unique about this case is how the investigating agency has been merged with the tribunal. How the powers which are given in CRPC have been very intelligently used to make sure that this entire process of compensation is concluded in the most reasonable period of time. And we have seen in the judgment and also in the procedure that the outer limit is 1 year. So see how the investigating agency is. Now, if we presume for the sake of argument that an accident has taken place, somewhere on the road, obviously the first person who reaches the spot is the investigating officer, because always invariably a call is made to 100 number, a call is made to the local police station. So investigating officer reaches the spot. Now, please compare and see how those forms are prepared. Now, those forms are so comprehensive that even an investigating officer who's not very intelligent, who's not trained, but if he follows this procedure, if he sees that each and every part of those forms, those annexures are filled properly, then it's an automatic process. So these forms are so comprehensive that investigating officer who reaches the spot, who has to find an eyewitness to the accident, examine the vehicle and meets the driver of the vehicle, offending vehicle, and also has the power and has a duty towards the victim who's there, who's injured, to do everything which is required in the domain of investigation. So that entire part of investigation now has been encapsulated and it is brought in the form of these reports, which are a part of procedure. So an effort was made to include the technology into this. Then how in case there is a CCTV recording, the CCTV recording should be brought in case the drivers and victims are carrying a phone, then their locations, then their telephone conversation in case there any, and in case the driver is under influence of alcohol, for instance, then his alcometer test will be done. All this is part of the entire procedure. So investigating officer who invariably has to do this and then file a charge sheet in the court will be doing not only the investigation for a criminal case, but will also be assisting the tribunal for the purposes of compensation. So in any case, he has to do this job. It is not that his statutory duty was only to file charge sheet in the court. Now his statutory duty is also to assist the tribunal. So the first, in case we see the duties of the investigating officer and the process which is given in the, in the judgment, the scheme which is given, which is at page number 9 of the annexure, 9 of 109, there the entire process, the duties of the investigating officer is. So an investigating officer is duty bound now to file a first accident report within 48 hours. So within 48 hours, which according to me is more than enough, because CRPC itself gives the time frame of 24 hours. Here he has been given 24 plus 24 hours. So 2 days to conclude the preliminary investigation. And in any case, I as a criminal lawyer feel that preliminary inquiry is more than enough. You don't need 10 days, 20 days, or maybe a month. So 48 hours have been prescribed here, reasonably, according to our understanding. It's reasonable, of course, subject to the enhancement of time, which of course the provision is there in the scheme, that in case the IO is unable to do it, then he can always ask for extension from the tribunal. But first accident report is prepared within 48 hours. It is given to the tribunal, it is given to the driver, it is given to the owner of the vehicle, it is given to the victim, it is also given to the legal aid society, the association, because they are very important part of this entire scheme. And also, wherever the police has a website, because now Delhi police at least has a website, so direction is given that please post it on that website. So see what the investigating agency or the stakeholders have achieved in 48 hours. preliminary investigation. Copies are sent to everyone. They all are aware of what has happened. They all are prima facie aware of who the victim is, who the accused is, who's responsible, how many vehicles were involved. All that information is readily available in 48 hours. So what a concept. I must compliment the concept again that in a shortest possible time, a major part of investigation which is available at the site is concluded and it is shared with all the stakeholders. Then you would see that the victims, of course, victim can be a person who's not an educated person. He can be, a pedestrian. He can be a cyclist. He can be on a scooter. So they are not aware of what their rights are. Now the investigating agency, the IO, has been made to inform each and every victim as to what their valuable rights are. So whatever the investigation has been conducted, what is the procedure which is now have become the rules, how they have to be communicated to the victims is also part of the investigating agency's duty. So conclude investigation in 48 hours, the investigation at the site, and also inform the victim. So major part is done. And then the driver and the car owners, they are very, very important part of this entire scheme. Now, very often, whenever there is a big car involved and there is a scooter involved, the natural reaction is that there must be a problem with the driver of the car because it's a bigger vehicle. So normally the tendency is to implicate them without even understanding as to who's responsible for the accident. Sometimes the pedestrians themselves are walking on the road, they are running on the road, the scooterist himself can be negligent. Of course, will be part of the investigation, but their information from them is also very important. Now, if driver is an accused or the vehicle owner is an accused, it becomes very difficult to elicit information from them. So I remember, Justice Midha was so cautious of framing these entire rules that he was very clear that please make sure that the constitutional rights of protection given under Article 21 or Article 20 Clause 3 should not be violated. So those forms which have been prepared are forms which have been prepared after taking into consideration the protection which is given to an accused. They have been told to provide it. So normally, if we go back and see how the tribunal used to function, this information which now is coming in 10 days or 30 days before the tribunal used to take about years, because in about 2 to 3 years, I remember as a young lawyer, we always used to wait for even the summons to be served on the respective parties. Forget about the investigation and the inquiry. And whenever we used to make an application before the tribunal to ask for the charge sheet which is already filed, the tribunal was reluctant because tribunal was of the view that I have to conduct my own inquiry and investigation. Why should I call a report from the police? But see how these two agencies have been merged very beautifully, where they all feel that yes, they are part of the criminal justice system and the the judicial system of grant of compensation, and how they have to perform their respective duties. So in 30 days now, what the tribunal has achieved is the first accident report, the driver's form, the owner's form, and then also the rights of victim have been communicated to them. So major work is already done. And in 50 days time, the IO, who's now seized off with the entire matter, will also give an interim accident report. Now, this report is very, very important to form a general opinion about what is happening at the investigation level. So this interim accident report is also given to the tribunal within, say, about 50 days. Again, to the driver, to the owner of the vehicle, the victim, the insurance company, and all the stakeholders who are involved. So within 50 days, the investigation is almost concluded. Now, very significant part of this entire scheme will emerge now, where the Honorable Court has very, beautifully merged the investigation and the final report, which is called detailed accident report. So 60 days period is given to the investigating agency to complete their investigation with regard to any criminal offense. When there's an accident which happens and, somebody dies, so offense under 304A is made out. If somebody's hurt, grievously hurt, then 337, 338 is made out, and all those offences are there, and also offences under the Motor Vehicle Act. Now see the advantage of these rules now. Advantage is not only the tribunal is getting the report within 60 days, it is also the criminal court which is now getting the investigation report under 173. So how an effective and efficacious system is adopted here, that both the investigation and the tribunal work is very expeditiously performed and reports are there in the court. Otherwise, I remember in 304A cases, very often, very often, because 304A cases normally or maybe an assistant sub-inspector who has a lot of work to do, who has a law and order problem, the duties to perform, he has investigation duties to perform. Very often we see that 304A charge sheet are not filed before 1 or 2 years. Now, in this case, with the help of these rules, even the investigation gets expedited. Now, the IO's job now is not only to make sure that the victims are secured, but also to make sure that driver and the owner of the vehicle, they give relevant information, the investigation and the trial, and all this reaches the tribunal. Now, Form 6A and 6B, which are at page 45, and I must compliment the Honorable Judge that he has taken into consideration the comprehensive part of the victim. Now, victim, normally nobody does an inquiry, with regard to the legal heirs, what and their financial status, what is the impact of the accident onto the victims. The entire accident of the investigating agency. Now, in this case, this Form 6A and 6B, which are at page number 45, is prepared. If you see, the forms are so comprehensively prepared that each and every relevant information with regard to the victims is already present with the court. Under normal circumstances, the tribunal would have conducted an inquiry. Here, the IO is assisting the tribunal, and victims are the one who are providing this information to the investigating officer in advance. And if there is no anomaly found, if there are no aberrations in this information, then of course the tribunal can accept these forms as it is. Now, if you analyze Form 6A, you will see that not only the FIR and other details are mentioned, and also the detail with regard to accidents are mentioned, but also the information with regard to victims. Now, their financial dependency on the deceased is already reflected here in the form. The income of the deceased is mentioned, and how many children are there is mentioned. Name, age, gender, relation, and marital status of legal representative is also mentioned. So, in a case of injury, there is a different information. In case of death, there is a different information. Now, another very important aspect of the matter which you must see is, see the analytical power of the Honorable Court here, that they also realize that sometimes there are minors who are the only sole bread owner, the father and the mother, maybe both of them die or one of them die. What is the condition of a child there? So this Form 6B is with regard to the legal rights of the minor children. This was also during the course of argument, this was also, deliberately done, and a very renowned, counsel who came in, filed an application on behalf of Bachpan Bachao Andolan and came up and said that you are doing such a wonderful job, but nobody is talking about minors. Then a comprehensive exercise again is done with regard to minors, and Form 6B is introduced, where of course the details of the minors are also given to the tribunal. So see how interim accident report, which is in 50 days, and finally the detailed accident report. If all these three reports coupled with the charge sheet or the final report, which we say under 173, is placed before the court, see the quantum of information, see the relevant information which is required for the purpose of trial is already there before the court and from all the stakeholders. So if I compare this exercise with the exercise of investigation under normal case of cheating, it's only the investigating officer who goes, collects information, records the statement, collect the evidence, oral and documentary, and then provide it to the court. See, this particular exercise is much more comprehensive than that, much more detailed than that. The investigating officer's own opinion is there, but in this system, in this entire process, which is envisaged so beautifully, all stakeholders are already providing their information and submitting to the court. So in my view, if this process is adopted, then I can at least say safely that 95% of cases can be solved without any dispute. Of course, there'll be certain disputes with regard to quantum. There'll be dispute with regard to certain facts which have been stated. But if everything goes normally, if it's a case of a normal accident where all things are transparent and provided to the tribunal in time, then tribunal will be able to release the money, pass an order with regard to compensation within 6 to 9 months. So if we see the entire exercise, now, of course, the IO also may face, certain difficulties. It's not that everybody will cooperate with the investigating officer. Now, see how those issues which can arise somewhere in future are also envisaged in this entire scheme. Now, the IO may face a situation where IO is not being cooperated. The driver is not cooperating. The owner says, I don't have the information and I can't give it to you in 48 hours. I can't give it to you in 50 days. Then what should the IO do? The investigating officer has an option, even in this scheme, to go to the tribunal. To go to the tribunal, file an application, tell the tribunal about the difficulties and take a judicial order. Sometimes the statutory power of the investigating officer is also not sufficient. Very often we see that investigating officers go to the court, take non-billable warrants, go to the court under 91, take an order for production of documents where the accused is not cooperating. 311, there are various provisions in CRPC which are normally used by investigating agency. Here again, that option is also available. If the investigating agency feels that their powers are not sufficient to extract information, then they can go to the tribunal and they can file an application, get an order, and then either search premises or tell the stakeholders to come and attend the proceeding in the tribunal. So that is also there. And of course, we are not saying that this scheme is so sacrosanct, then each and every case will function like this, and within this time frame everything will be over. There may be cases where the information is not available, genuinely not available. There may be information where the driver is from a far-flung area, or there may be a situation of hit and run, for instance, where somebody has hit the victim and has run away. And sometimes you don't have the wherewithal to start the investigation. You don't have any information. Sometimes we don't even have the eyewitnesses to an accident. Those cases, of course, cannot be concluded in 48 hours. They can't be concluded in 30 days. So when the IO feels that there's a peculiar case where information is not forthcoming, the IO can certainly go to the tribunal and seek extension. So in the investigating agency, in fact, I have told, not be changed in every case. But yes, if you want extension, go to the tribunal and seek extension. 23 report is concerned, although in this scheme, it is time bound, but in CRPC, there is no time limit. So ultimately, the time has to be sought from the tribunal. And of course, it has to be on justifiable reasons. There have to be some grounds on the basis of which the extension can be given. Now, imagine a situation where you don't have a driver. The license which is also fake and fabricated, what does the investigating agency do? Those are extreme cases where investigating agency has to perform its duty, statutory duty, investigate, and may also add sections with regard to forgery. The normal case, this was never done before. In fact, this is also, something which which was manifested during the course of argument, and Justice Midha was of the view that, look, there are cases where all these documents are forged, but then the forgery sections are not, invoked in this entire investigation. So here again, sufficient time was spent on this, and this situation was also analyzed. where we see that sometimes the transport departments are also involved in cases of forgery of driving licenses. We have people, in fact, recently I did a case of drunken driving where a child who's actually was less than 18 was driving, met with an accident, somebody died. When investigation was conducted, the investigating officer found he is carrying a license from some place in Manipur. Of course, when he is less than 18, where's the question of driving license? But we all know we live in a society where sometimes the parents don't understand what they are doing. They don't understand the ramification, the after effect of permitting their young child to drive the car on the road, and ultimately it ends up in an accident. So there, these fake and fabricated driving licenses are also part of investigation. So IO, of course, has an option to include the sections of forgery, include the section of other offences under Indian Penal Code with the investigation of 304 and file charge sheet in the court. So that is also there. So if we see, if you have this judgment, then page 35 of the judgment is that flow chart. In fact, anybody who has already read it or who wants to understand, for him, the moment he looks at the flow chart, he will understand what this entire scheme is all about. And it is so beautifully framed by the Honorable Court that each and every timeline is mentioned, each and every duty of the department, whether it's the insurance company, whether it is the investigating officer, whether it is a tribunal, it is specifically mentioned here. So at a glance, this is the best chart which gives you an at a glance view of the entire scheme. There are so many schemes which are in circulation, which are also formulated by the government, but they are so difficult to comprehend. But here the scheme is so beautifully framed that it is so easy to understand. Just one page, if the investigating officer clips the page on the board in front of him, in his office, he can just follow, and he will see that if he follows this scrupulously, the investigation is automatic. But last but not the least, I must say that these are cases which should be investigated by investigating agencies, and the officers who are deputed, they should be trained officials. And also the tribunal, the honorable judges who are posted in those tribunals, they should also be trained to make sure that how to deal with this. These are cases which have to be dealt with lot of sensitiveness, with lot of the compliances have to be seen, the timeline has to be seen, so it has to be scrupulously followed. So training to the investigating agency, to the officers concerned, training to the tribunal, training to the insurance company officials. Now, insurance company officials in this case have a role to play. It's not necessary that they have to object. It's not necessary they have to challenge each and every investigation. That is why if you see this chart, right in the bottom, there are 3 columns which are mentioned. First is, if everybody says that yes, calculation is good, we have seen it, investigation is in accordance with law, all facts are relevant, we are not disputing, then a consent award is passed. And minimum time for that consent award, in my view, according to chart, is 6 months. So I don't think anywhere in the world you can get a system where within 2 months, the insurance company releases the check to the credit of the victim. This can happen only here in India if we follow the scheme very, very scrupulously. Similarly, if there may be instances where the insurance company may not agree on quantum, but may agree on the facts of the case. Insurance company may say everything is fine, we accept the report, we accept all 3 reports filed by the investigating officer, but we are not very happy with the compensation. I think it is too steep, or it is exorbitant. Then, of course, an opportunity is given to both the sides. They can file their written submissions, they can challenge. And there, of course, additional 3 months are given to the tribunal to decide those cases. So 6 months for a consent award, 9 months for an award where only the quantum is in dispute. Rest, things are accepted by all the parties. And third situation, which is envisaged, where of course everything is disputed. There again, I think the Honorable Court has put up a timeline that if you challenge everything, if all facts are challenged, all reports are challenged, and everything is challenged in the court of law, then in 1 year you should conclude everything. So see a situation where IO concludes the investigation, file all the 3 reports, and in 90 days, and there is a dispute in quantum, then still the tribunal has at least 6 to 7 months to decide, which in my view is more than enough. And one thing which, of course, I must say beyond the scheme is that we must equip our courts with technology. If we equip our courts with technology, if the technological services are available, if computers are available, then we will see even this time frame can be reduced. I remember doing a trial in Greece, I think about 3-4 years back, where in the trial, when we went and we saw, the trial courtroom, we realized that every felony trial in Greece is conducted by at least 3 judges. So anything which is punishable for more than 5 years, which according to us, like we have offences which are triable by sessions court, there are offences triable by magistrate court, there are quantum of sentence involved. In that part of the world, anything above 5 trials is conducted by 3 judges. So the likelihood of mistake, the likelihood of any anomaly in the trial is reduced because there are at least opinion of 3 judges. So we can see in our country also that something like this can be formulated. But second most important part which I want to share with you all is the use of technology. So when we went and we started the trial, of course, my job was to assist the local lawyer, who was a Greek lawyer, is that at least 22 witnesses on that day in had a mic, the prosecutor had a mic, the complainant lawyer had a mic, and the accused lawyer also had a mic, and the witness also has a mic. So witness is called, witness comes, he starts giving deposition, and the cross-examination starts. There is no typing happening. There is no deposition which is being recorded by hand. It's only digitally recorded. And at least 15 to 17 witnesses examined in less than 4 to 5 hours. And all those witnesses who were examined digitally in the evening or maybe after 24 hours, the recording is given to each and every party. And later on, the transcripts were prepared. So imagine a situation like Greece in India, where this entire process, which is happening, where timeline is given 48 hours, etc. All this is digitally sent to the court. All this is respective parties. All this is recorded in the form of technology, and then orders are passed. I'm quite sure even this period of 6 months can be reduced, and the period of 9 months, 12 months can be further reduced. So in my view, this scheme, which is beautifully conceptualized, is used with technology. It can certainly be very, very effective, and I'm sure that victims in our country will be compensated in the shortest possible time. So this is in fact what I could read from the judgment and from the flowchart, and I could see that yes, this scheme can really work to the advantage of all the parties. The trials can be concluded at the earliest. All thanks goes to Justice Midha, who has conceptualized it, of course, with the help of some lawyers and the amicus curiae who were appointed, and also the stakeholders. But he has taken on his shoulder single-handedly. I have no qualms to say it. I must say it openly. It was his brainchild, started in 2009, concluded in 2021. And it has a great, great judicial history. It's very seldom we find cases which has a history of the court proceedings of more than 10 years. Out here, it has a history of more than 10 years, 11 years. And if we see how it has developed, it is remarkable. And we must pay compliment to Justice Midha for that. Unfortunately, I couldn't share the screen with him today, but I have no qualms to say, and he has done a great, great job. And the government, the Supreme Court has accepted this. In fact, Supreme Court has been accepting all the procedures which are envisaged by him. We have Rajesh Tyagi 1, we have Rajesh Tyagi 2, we have Rajesh Tyagi 3. Even the second one was accepted by the Honorable Supreme Court in the case of Jay Prakash versus National Insurance Company. And third, of course, is the most comprehensive, which is accepted by the Supreme Court. The DCP legal cell was available throughout. He cooperated, with the court and gave his full support. And we must say that Delhi police, right from day one, was open, was always. In fact, I remember interacting with the joint commissioners at that point of time in 2009. They never created any impediment in the formulation of the scheme. They always said, yes, we would like to do it. We want this system to improve. They were more than conscious about the delays which are happening, the doubts which are there in this entire system. And if we use technology, I must add one more point to this, is if we add technology to this entire process, we will make sure that there are no fake claims. We make sure that there are no doubts in between. Compensation for you in the court, and we will charge X amount of money. At least in India, that thing is not possible. And we can say that in India, that thing does not exist. With this kind of a procedure, we can also avoid that. And we can make sure that the victims get more than 100% of the payment which they deserve. So I think this is what I can add to what Justice Midha must have already said in the morning. And if investigating agencies cooperate, they follow this in its letter and spirit, I don't think there will be any problem. I don't think the police can say that this is a kind of a scheme which they can't follow. Even an ordinary investigating officer in the rural areas, if this scheme is given to him in a vernacular language, he can certainly perform very well and can be a great asset to this entire judicial system. So I can only say thank you so much. In case anybody wants to ask any question, any clarification, I'm open to it. I can answer them. In case there are any doubts, of course, Justice Midha was there, and we have Mr. Jain who will be coming. Mr. Jain played a very, very important role. Mr. Jain, who probably is the next speaker, is the person who deals with this day in and day out. He had such marvelous, practical, pragmatic knowledge about this procedure. His inputs were very nice and very valuable, I would say, for passing a judgment like this. So thank you so much, sir, for inviting me and giving me the opportunity.
Thank you, Mr. Vikas Pahwa. I know you have been a part of it at different levels and different stages and contributed in that particular process. And therefore you could share the entire aspect, particularly immigration aspect in such matters. The investigation and further carrying out the entire trial for that matter. If it is expedited, it makes such a difference. And that is exactly the contribution which Justice Midha has made in this entire process. I remember my own days, how long it used to take, the entire process. And a particular amount of compensation given, say 10 years back, look at it, the amount would be just nothing if it is not paid for another 10 years or 15 years for that matter. This is what is the jurisprudence now, which has been developed in this particular context. Thank you so much, Mr. Pahwa, to be with us